Hello, welcome back. GovDoc Breakdown, no opinions, just facts and summaries of government documents, and we let you take it from there. Back again, June 12th, Supreme Court opinion, Martin v. the United States. Alright, this is kind of an important one for citizens' rights in terms of the federal government, so let's get into the case. In 2017, the FBI raided the wrong house in suburban Atlanta while trying to arrest suspected gang members. Officers used flashbang grenades, handcuffed the residents, and pointed weapons at them before realizing their mistake. As a result, the Martin family sued the U.S. government for damages under the Federal Tort Claims Act, or the FTCA, claiming the raid involved both negligence and intentional misconduct like assault and false imprisonment. Alright, so before we get into the case, let's take a look at the Federal Tort Claims Act, or the FTCA. This lets people sue the federal government when its employees commit torts or harmful acts, like assault or negligence while doing their jobs. But there are exceptions. One, the intentional tort exception, which says normally you can't sue for things like assault, battery, or false imprisonment. Two, the law enforcement proviso, which is in response to the intentional tort exception, and it's a special rule that makes an exception to that exception, saying you can sue for 6 specific harmful acts like assault or false arrest, if a federal law enforcement officer committed them, and that's important. And 3, the discretionary function exception, saying you can't sue if the harm was caused by a federal employee making a judgment call. A discretionary decision, basically, even if they made a bad one. So, in this case, we are dealing with 2 legal questions around the Federal Tort Claims Act. Does the law enforcement proviso, which allows you to sue for those 6 harmful acts, apply to just the intentional tort exception, or does it override other parts too, like the discretionary function exception? Also, not related to the FTCA, can the government avoid responsibility for the officer's actions by saying they were carried out under federal authority, using the supremacy clause of the Constitution, which basically says that the federal law beats state law? That's kind of like what the whole Civil War was about. Like, federal law supersedes state law. So, the Supreme Court took a look, and here is what they said. In terms of the law enforcement proviso, they said it only applies to the intentional tort exception and not to other sections of the law. In terms of the supremacy clause defense, the court said that this is not a valid defense that the government can use. The FTCA says the federal government should be treated like a private citizen would under state law. So, the case is being sent back down to the courts where they must decide whether the discretionary function exception applies to this case. So, did the FBI agent involved in the raid have legal leeway to make the decision that led to that mistake, basically? And whether a private person in Georgia would be liable for doing the same thing, since the FTCA treats the U.S. government like a private citizen in these matters. And in general, this case clarifies how the government can and cannot defend itself when its officers make mistakes during law enforcement operations. All right, bit of a complicated one there, but we got through it. Kaimo, keep your mind open, do your own research, form your own opinion. See you in a little bit.